Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so we can update you every time that we upload new content. It's our goal to upload new content every morning at 8 a.m. Eastern Standard Time. Question number 1. Actor, a well-known movie star, was drinking vineyard wine at a nightclub. A bottle of the vineyard wine with its label plainly showing was on the table in front of actor. An amateur photographer asked actor if he could take his picture, and actor said yes. Subsequently, the photographer sold the photo to Vineyard, without actor's consent, used the photo in a wine advertisement in a nationally circulated magazine. The caption below the photo stated, "Actor enjoys his vineyard wine." If actor sues Vineyard to recover damages as a result of Vineyard's use of the photograph, will the actor prevail? A. No, because actor consented to being photographed. B. No, because actor is a public figure. C. Yes, because Vineyard made commercial use of the photograph. Or D. Yes, unless actor did, in fact, enjoy his vineyard wine. Take 10 seconds. Choose the best answer. Best answer here would be C, yes, because Vineyard made commercial use of the photograph. Invasion of privacy actions are 1. Appropriation, 2. Intrusion, 3. Publicity of private life, and 4. False light. Appropriation is the unauthorized use of plaintiff's name or picture by the defendant for the defendant's own benefit. In this case, Vineyard used the photo of actor for Vineyard's benefit by placing the photo in a wine advertisement in a nationally circulated magazine. Vineyard bought the photo from an amateur photographer and made no effort to ascertain whether the picture was authorized by actor to be used in this advertisement. This appropriation is an invasion of actor's privacy. Therefore, actor will prevail because Vineyard made commercial use of the photograph. Question number 2. Jones wanted to kill Adams because he believed Adams was having an affair with his wife. Early one morning, armed with a pistol, he crouched behind some bushes on a park hillside overlooking a path upon which Adams frequently jogged. On this morning, however, Jones saw Adams jogging on another path about half a mile away. Nonetheless, Jones fired 5 shots at Adams. None of the 5 shots came anywhere close to Adams, as he was well out of the range of the pistol Jones was using. Jones is A. Guilty of attempted murder if he was not aware of the limited range of the pistol. B. Guilty of attempted murder if a reasonable person would not have been aware of the limited range of the pistol. C. Not guilty of attempted murder or any lesser included offense, because under the circumstances it was impossible for him to have killed Adams. Or D. Not guilty of attempted murder, but guilty of assault. Take 10 seconds. Correct answer is A. Guilty of attempted murder if he was not aware of the limited range of the pistol. In order to be guilty of attempt, the defendant must 1. Have intended to commit the crime, and 2. Took a substantial step towards completing the crime. Regardless of the underlying crime, attempt is always a specific intent crime. The intent required to actually commit the target crime is irrelevant to attempt. In this case, Jones wanted to kill Adams, so he crouched behind some bushes, and in an attempt to ambush Adams on his morning jog, Adams took a different path, however, appeared on a path further away than Jones expected, but Jones shot at him 5 times nonetheless. This is clearly a substantial step towards completion of the crime. This issue, however, is whether Jones had the specific intent to murder Adams at the time he fired the shots from half a mile away, because Adams was well out of the range of the pistol Jones was using. If Jones was aware of this limitation on his weapon, he did not act with the intent to murder Adams, because it was not possible. As such, Jones is only guilty of attempted murder if he was not aware of the limited range of his pistol. Question number 3. Breeder bought a 2-month-old registered boar at auction from Pigstyle for $800. No express warranties were made. 15 months later, tests by experts proved conclusively that the boar had been born incurably sterile. If this had been known at the time of the sale, the boar would have been worth no more than $100. In an action by breeder against Pigstyle to avoid the contract and recover the price paid, the parties stipulate that as both were and have been aware, the minimum age at which the fertility of a boar can be determined is about 12 months. Which of the following will the court probably decide? A. Breeder wins because the parties were mutually mistaken as to the boar's fertility when they made the agreement. B. Breeder wins because Pigstyle impliedly warranted that the boar was fit for breeding. C. Pigstyle wins because breeder assumed the risk of the boar's sterility. Or D. Pigstyle wins because any mistake involved was unilateral, not mutual. Take 10 seconds. Correct answer is C. Pigstyle wins because breeder assumed the risk of the boar's sterility. The implied warranty of merchantability is that goods sold by merchants must be fit for their ordinary purpose. In this case, process of elimination is helpful in choosing the best answer. A and D can be eliminated right away because there was no mistake made regarding the boar's fertility. Both breeder and Pigstyle knew that the boar was 2 months old and that the minimum age with which fertility of a boar can be determined is about 12 months. Similarly, B is eliminated because Pigstyle could not have impliedly warranted that the boar was fit for breeding when both parties knew the boar had to be about 12 months old to determine fertility. The only answer remaining is C. Breeder assumed the risk of the boar's sterility since breeder knew fertility could not be determined in this 2-month-old boar. Question number 4. A statute of the state of East Dakota requires each insurance company that offers burglary insurance policies in the state to charge a uniform rate for such insurance to all of its customers residing within the same county in that state. So long as it complies with this requirement, a company is free to charge whatever rate the market will bear for its burglary insurance policies. An insurance company located in the state of East Dakota files suit in federal district court against appropriate East Dakota state officials to challenge the statute on constitutional grounds. The insurance company wishes to charge customers residing within the same county in East Dakota rates for burglary insurance policies that will vary because they would be based on the specific nature of the customer's business, on its precise location, and on its past claims record. In this suit, the court should A. Hold the statute unconstitutional because the statute deprives the insurance company of its liberty of property without due process of law. B. Hold the statute unconstitutional because the statute imposes an undue burden on interstate commerce. C. Hold the statute constitutional because the statute is a reasonable exercise of the state's police power. Or D. Abstain from ruling on the merits of this case until the state courts have had an opportunity to pass on the constitutionality of this state statute. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. Hold the statute constitutional because the statute is a reasonable exercise of the state's police power. States and local governments have general police power, but there's no general federal police power except for 1. The military, 2. Federal lands and territories, 3. Native American lands and reservations, and 4. The District of Columbia. Police power is the capacity of the states to regulate behavior and enforce order within their territory for the betterment of the health, safety, morals, general welfare of a state's population. In this case, the statute of the state of East Dakota requires each insurance company that offers burglary to charge a uniform rate for such insurance to all its customers residing within the same county in that state. So long as this requirement is satisfied, the insurance company is free to charge whatever rate the market will bear for its burglary insurance. This statute does not discriminate against out-of-staters, nor does it place an undue burden on interstate commerce. As such, the statute is a valid exercise of East Dakota's police power. Question number 5. In a contract litigation between Pixley and Dill, a fact of consequence to the determination of the action is whether Pixley provided Dill with a required notice of Dill's branch office in the state capital. Pixley introduced evidence that he gave notice at Dill's office in the city of Capitan. Although Capitan is the state's capital, Pixley failed to offer proof of that fact. Which of the following statements is most clearly correct with respect to possible judicial notice of the fact that Captain is the state's capital. A. The court may take judicial notice even though Pixley does not request it. B. The court may take judicial notice only if Pixley provides the court with an authenticated copy of the statute that designates Captain as the capital. C. If the court takes judicial notice, the burden of persuasion on the issue of whether Captain is the capital shifts to Dill. Or D. If the court takes judicial notice, it should instruct the jury that it may, but it is not required to, accept as conclusive the fact that Captain is the capital. Take 10 seconds and choose the best answer now. Best answer is A. The court may take judicial notice even though Pixley does not request it. A court may recognize as true indisputable facts that are common knowledge or capable of verification by sources of unquestionable accuracy. If not requested, courts have discretion to take judicial notice. In a civil trial, the jury must accept the judicial notice because it is conclusive in civil cases. Here, the court has discretion to take judicial notice of Captain being the state's capital because it is common knowledge within the jurisdiction. The jury must accept as conclusive the fact that Captain is the capital. Pixley does not have to request the court to take judicial notice. Thus, the only answer option that is most clearly correct with respect to possible judicial notice of fact that the Captain is state's capital is answer A. Question number 6. As Seller, an encyclopedia salesman, approached the grounds on which Hermit's house was situated, he saw a sign that said, "No salesman. Trespassers will be prosecuted. Proceed at your own risk." Although Seller had not been invited to enter, he ignored the sign and drove up the driveway towards the house. As he rounded a curve, a powerful explosive charge buried in the driveway exploded and Seller was injured. Can Seller recover damages from Hermit for his injuries? A. Yes, if Hermit was responsible for the explosive charge under the driveway. B. Yes, unless Hermit, when he planted the charge, intended only to deter, not to harm, a possible intruder. C. No, because Seller ignored the sign which warned him against proceeding further. And D. No, if Hermit reasonably feared that intruders would come and harm him or his family. Take 10 seconds and choose the best option now. The best option here would be A. Yes, if the Hermit was responsible for the explosive charge under the driveway. The general rule is that a person may use reasonable force to defend their property. The use of deadly force, however, is prohibited in the defense of property. In this case, Hermit had placed a sign on his property warning no salesman. Trespassers will be prosecuted. Proceed at your own risk. Seller ignored the sign, drove onto Hermit's property, and was subsequently injured by a powerful explosive charge buried in Hermit's driveway. Since the use of deadly force, such as powerful explosive charges buried in Hermit's driveway, is prohibited in the defense of property, Seller can recover from Hermit for his injuries if Hermit was responsible for the explosive charge under the driveway. Let's look at a little bit of analysis of the other answers. B. Yes, unless Hermit, when he planted the charge, intended only to deter, not to harm, a possible intruder. His intent when he planted the charge, if he did in fact plant the charge, would be irrelevant. It is the outcome that would be relevant. So if he intended only to deter someone, but he in fact blew someone up, he would still theoretically be guilty of murder, or could be charged with murder. C. No, because Seller ignored the sign which warned him against proceeding further. Now the issue here is that the sign was not in fact specific, nor did it warn of any physical harm at all. It just says, beware. That's not sufficient to put the salesman on notice. As a result, the homeowner would still be liable. D. No, if Hermit reasonably feared that intruders would come and harm him or his family. Again, we're facing the issue of reasonable force in response. At the time of the planting of the explosive charge, there was no force, in fact, being utilized. So taking the level of excessive, deadly force immediately in response to anything would be inappropriate because, in fact, there is no force to respond to at that time. So as a result, A is the only possible correct answer. Question number 7. Plagued by neighborhood youths who had been stealing lawn furniture from his backyard, Armando remained awake nightly, watching for them. One evening, Armando heard noises in his backyard. He yelled out, warning intruders to leave. Receiving no answer, he fired a shotgun filled with non-lethal buckshot into bushes along his back fence where he believed the intruders might be hiding. A 6-year-old child was hiding in the bushes and was struck in the eye by some of the pellets, causing loss of sight. If Armando is charged with second-degree assault, which is defined in the jurisdiction as maliciously causing serious physical injury to another, he is A, not guilty because the child was trespassing and he was using what he believed was non-deadly force. B, not guilty because he did not intend to kill or to cause serious physical injury. C, guilty because he recklessly caused serious physical injury. Or D, guilty because there is no privilege to use force against a person who is too young to be criminally responsible. Take 10 seconds and choose the best answer now. If you chose option C, guilty because he recklessly caused serious physical injury, you'd be correct. Second-degree assault is defined in this jurisdiction as maliciously causing serious physical injury to another. Malice is an intentional or reckless disregard of an obvious or known risk. Here, Armando fired a shotgun into the bushes where he believed the intruders might have been hiding. Firing non-lethal buckshot at bushes where someone might be hiding is a reckless disregard of an obvious risk. Armando ended up hitting a 6-year-old child hiding in the bushes. Armando's reckless shooting caused the child a serious injury. As such, Armando is guilty of second-degree assault because he recklessly caused serious physical injury. Let's go through the eliminated options of A, B, and D. Let's start with D, guilty because there is no privilege to use force against a person who is too young to be criminally responsible. It seems to be irrelevant immediately because Armando wouldn't have known the age of the trespasser, and it is also skipping the fact that generally you cannot use physical force of any kind against an individual who's not in fact threatening you whatsoever. Here, it's clear that the child was at a distance, the child was not threatening, the child was hidden in bushes, it wasn't even visible to Armando. As a result, D does not make sense in light of the facts. B, not guilty because he did not intend to kill or cause serious physical injury. So if we look at the definition under the statute, which is maliciously causing serious physical injury to another, the option B would seem to be discussing an entirely different standard. So as a result, option B should simply just be eliminated right off the bat. Not guilty because he did not intend to kill or cause serious physical injury. Neither nor would be applicable to this standard under this statute. Option A, not guilty because the child was trespassing and he was using what he believed was non-deadly force. Please remember that it's not the use of non-deadly force that's permitted under any circumstance. It's the use of reasonable force in response to the force that one is met with. Here, there is no force because the child is at a distance, in bushes, not visible, and in essence, there is no threat other than fear or intimidation on the part of Armando at that time. But there is no physical threat to him. So for him to respond with a physical response would immediately be inappropriate under the statute. Question number 8. Gourmet purchased the front portion of the land needed for a restaurant he desired to build and operate, but the back portion was subject of a will dispute between Hope and Faith, two sisters. Hope's attorney advised her that her claim was doubtful. Gourmet, knowing only that the unresolved dispute existed, agreed in a signed writing to pay Hope $6,000, payable $1,000 annually, in exchange for a quitclaim deed from Hope, who promptly executed such a deed to Gourmet and received Gourmet's first annual payment. Shortly thereafter, the probate court handed down a decision in Faith's favor, ruling that Hope had no interest in the land. This decision has become final. Gourmet subsequently defaulted when his second annual installment came due. In an action against Gourmet for breach of contract, Hope will probably A, lose because she was aware at the time of the agreement with Gourmet that her claim to the property quitclaimed was doubtful. B, lose because Hope suffered no legal detriment in executing the quitclaim deed. C, win because Gourmet bargained for and received in exchange a quitclaim deed from Hope. D. When, because Gourmet, by paying the first $1,000 installment, is estopped to deny that his agreement with Hope is an enforceable contract. Take 10 seconds. If you chose option C, When, because Gourmet bargained for and received in exchange a quitclaim deed from Hope, you'd be correct. A valid contract requires an offer, an acceptance, and consideration, and no defenses to formation. Courts generally do not inquire into the adequacy of consideration. In this case, Gourmet, knowing that an unresolved dispute existed, agreed in a signed writing to pay Hope $6,000, payable $100 annually, in exchange for a quitclaim deed from Hope. This is a valid contract, and as such, Hope will probably win in an action against Gourmet for breach of contract. As to the other options, A, lose because she was aware at the time of the agreement that her claim to the property quitclaimed was doubtful. In fact, it's the exact opposite. It's the fact that the other party was aware of the situation and as a result did not know what the outcome of that situation was and still bargained for this contract. B, lose because Hope suffered no legal detriment in executing the quitclaim deed. Well, at the time of the agreement, it wasn't known whether she'd suffer any detriment or not, and in fact, she gave what she contracted to, which was the quitclaim deed. And finally, option D, win because Gourmet, by paying the first $1,000 installment, is stopped to deny that his agreement with Hope is an enforceable contract. This is a bit irrelevant. This goes a bit too far. It's addressing the issue of the contract and the enforceability of it as a result of the payment. However, the reality is that the contract is enforceable not because of the payment, but because of the actual agreement, the actual negotiation, and the fact that the item that was agreed upon and negotiated was in fact tendered, the quitclaim deed. So as a result, C is more correct because the likelihood of this being enforced as a result of the negotiation and the bargain for exchange is in fact the reason why this would likely be enforced. Question number 9. Widgets are manufactured wholly from raw materials mined and processed in the state of Green. The only 2 manufacturers of widgets in the United States are also located in that state. However, their widgets are purchased by retailers located in every state throughout the United States. The legislature of the state of Green is considering the adoption of a statute that would impose a tax solely on the manufacture of widgets. The tax is to be calculated at 3% of their wholesale value. Which of the following arguments would be least helpful to the state in defending the constitutionality of this proposed state tax on widgets? A, at the time the widgets are manufactured and taxed, they have not yet entered the channels of interstate commerce. B, the economic impact of this tax will be passed on to both in-state and out-of-state purchasers of widgets, and therefore it is wholly non-discriminatory in its effect. Or C, because of the powers reserved to them by the 10th Amendment, states have plenary authority to construct their tax system in any manner they choose. And D, a tax on the manufacture of widgets may be imposed only by the state in which the manufacturing occurs, and therefore it is not likely to create the danger of a multiple tax burden on interstate commerce. Choose which you believe is the worst answer, A, B, C, or D. Take 10 seconds and choose now. Correct answer would be C. Because of the powers reserved to them by the 10th Amendment, states have plenary authority to construct their tax system in any manner they choose. The Supreme Court has set out a 4-part test for the state and local taxes on interstate commerce to be valid under the Commerce Clause. 1. The tax must not discriminate against out-of-state competition. 2. Must be applied to an activity that has a substantial nexus with the taxing state. 3. Must be fairly apportioned to the activities taking place in the taxing state. And 4. Be fairly related to services provided by the taxing state. Answer C would be the least helpful to the state in defending the constitutionality of this proposed tax because it is an incorrect statement of the law. The 10th Amendment states the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively, or to the people. This does not give states plenary authority to construct their tax systems in any manner they choose. So as a result, C would be the worst option because it is, in fact, a misstatement of the law and the rule. Question number 10. In an automobile negligence action by Popkin against Dwyer, Juilliard testified for Popkin. Dwyer later called Watts, who testified that Juilliard's reputation for truthfulness was bad. On cross-examination of Watts, Popkin's counsel asked, and isn't it a fact that when you bought your new car last year, you made a false affidavit to escape paying the sales tax? The question is, A, proper, because it will indicate Watts' standard of judgment as to reputation for truthfulness. B, proper, because it bears on Watts' credibility. C, improper, because character cannot be proved by specific instances of conduct. Or D, improper, because one cannot impeach an impeaching witness. Take 10 seconds. If you chose option B, proper, because it bears on Watts' credibility, then you're ready to litigate cases right now. Let's get to it. Under the federal rules, the credibility of a witness may be attacked by any party, including the party calling that witness. Acts of misconduct by a witness that did not result in a conviction are admissible to impeach in both civil and criminal cases if those acts involve lying. In this case, Watts testified that Juilliard's reputation for truthfulness was bad. Popkin's counsel seeks to attack Watts' credibility by cross-examining Watts about making a false affidavit to escape paying sales tax. This misconduct involves lying, so it can be used to impeach Watts. Thus, the question is proper because it bears on Watts' credibility. As always, thank you for joining us on Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so that you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time and to help you prepare for this exam each and every day up until the exam.